So hello, everyone. Welcome to today's webinar on behalf of Transform Europe. My name is Katerina Anastasiou, and I'm the facilitator of the Focus Topics Migration and Global Strategy. One sentence for Transform Europe, in case you don't know us yet, we're a network of over 35 foundations, political foundations of the left around Europe, from more than 20 countries, one of them being also the Rosa Luxemburg Foundation. And yes, today I will be your silent moderator. I have the job of welcoming you in today's webinar, where we are going to explore the strategic importance of litigation or legal mitigation in our struggle to try to stop and resist the normalization of pushbacks. I want to tell you as well that this is the first webinar of 3 webinar series on the same topic. The upcoming webinar, and perhaps you can already note in your calendars, will be taking place on the 30th of March, where we will be hearing from comrades, colleagues, and friends from all around Europe, border stops where pushbacks are taking place, including also the Mediterranean. And then on the 6th of April, we will be presenting a new study drafted by 2 scholars, concentrated on the role of Austria and its connection to Fortress Europe and its practices. So after this short introduction on my side, and before I turn off my camera, I would like to pass the floor to Monika Mokre. I think she doesn't need a lot of introduction, but also representing EIPCP today here, and she will be moderating on camera our webinar today. For everything you need, you can communicate with me in the chat. Of course, you can feel free to also use the Q&A box, but as I told you, after the first presentations, we will stop the recording and promote everyone to speakers, so you can also take the floor easily if you want. Thank you very much and have a good webinar. I'm very excited.
Thank you, Kat, and welcome also from my side. Following up on what Kat said, I would strongly suggest that we all discuss then, not in writing, but in speaking, because I think there are many people here in this room who have a lot to contribute to that. So it's rather a discussion among all of us than there are the experts and then the ones who should listen. Nevertheless, we have 3 wonderful experts here for this first round of this webinar, and I'm very happy to present them and to moderate today. Maybe some of you who were registered earlier didn't even realize that more or less in the last minute, also Nikola Kovacevic joined us as a speaker, and we're very happy about that. So we now have 3 lawyers from Italy, from Austria, and from Serbia talking about these issues. We will start with the presentation of Gianfranco Schiavone, and I will present him now, and then the speakers before they start to speak, because otherwise we will probably not follow up all these important things that these people are doing. So Gianfranco is the president of the Italian Consortium of Solidarity, one of the associations that contributed to build a reception system for refugees in Italy. And this consortium has been operating in Trieste for 25 years. He's also a member of ASGI, the Association for Juridical Studies on Immigration, and he has been the vice president there for a long time. ASGI now is an association of legal scholars and lawyers that was founded 31 years ago. ASGI and ICS, together with other organizations, have created a network, Rivolti ai Balcani, which is a coordination that draws the attention of Italian society and politics to the very serious violations of migrants' rights along the Balkan route. And he also knows a lot about our question here of pushbacks and what we can do legally about that. So please, Gianfranco, the floor is yours.
Thank you very much. The presentation is too long, but I hope to tell to all the persons who are now online to tell something useful in my bad English. And so I underline my activities in ICS and in ASGI because I'm, in my opinion, all the activities that we have realized in Italy against illegal pushback along the Balkan route, in particular when they happen, this illegally pushback happened also in Italy, is strictly linked our success in realize some goal to stop this readmission is strictly connected to a choice that we have made, the choice to realize a network in Italy with legal association, social and political association, and make an activities on a different level on legal about strategic litigation, but in the same time we have involved association for accommodation, for social assistance of asylum seekers and refugees, because even we have made an activities only on the legal plan, I'm sure that we was not possible to reach the goal that we had reached, because we have tried to follow the person who are victims of a pushbacks along all the steps of this chain pushback, and we have tried to make a legal assistance to them in about the illegal pushback from Italy, but when the person stay abroad in other country, in Slovenia, in Croatia, or in Bosnia, and in the same time, this person we have understood that it's very important to follow this person only not only on a legal basis, but only on a solidarity basis, because these persons who are illegally pushbacks from Italy disappeared in the other countries, and if we haven't followed them with association of volunteers, international volunteers, if in the country in which they live are obliged to live, and if we haven't make assistance, even material assistance to them for even for long period or medium period, all this person it was impossible for us to go on to some litigation on the court in Italy, and in the same time continues to have a relationship with the persons. And I think that in this the base of our action was to create with link, and so we have created an Italian network which name is Rivolti ai Balcani, and that even ECS and ASGI and others like Amnesty International and others association belong to this network, and all together we realize monitoring the situation along the Balkan route with different persons, and try to contact the person who are available to make a litigation against Italy. This is the general, our general approach, and follow this approach. We have had the possibility to contact persons who are available to do this long action, because they wait for several months during our legal action was going on, but at the end we have realized, as I say later, we have realized an important success in the Court of Rome against the readmission of one person particularly, and about other persons who have just come in Italy. We now we have started other litigation about to have a sort of to demonstrate in any case, even if this person are in Italy now, even that when they have pushed back this action by Italian authorities was illegal. And we continue to have contacts with a lot of persons who became is a testimony of this story, even for newspaper, even for political actions, etc. And we create also a network between the person, a group of persons that are victims of these illegal pushbacks, and we think that we must continue this legal plane to even now the illegal admission from Italy is not active in this the last year. They stopped in the January of the last year, and now in this period we haven't illegal admission. But as I say later, this perspective, bad perspective, is always open because some different we have a lot of political pressure to renew these illegal readmissions. I don't know if you want to continue to explain what we have made, or we make another round table.
We can go to Petra maybe, and then later on talk about more concretely. Yes. This works for you? Okay, thanks a lot, Gianfranco. So our next speaker will be Petra Leschatz. Petra is a lawyer, and she's working in a women's center in Graz in Austria, doing legal advice, general advice for women, and also adult education. She has been a member of Border Crossing Spielfeld since 2015. Border Crossing Spielfeld is a network supporting refugees and migrants, especially at the Styrian border, but not exclusively there. And she's also a founding member of Pushback Alarm Austria, which was founded a bit more than a year ago, and which is a hotline for people who are entering Austria and want to claim for asylum and are afraid of a pushback. Please, Petra.
Thanks, Monika. Monika is also is always very kind, promoting me to a lawyer, which I'm actually not. I graduated from law school and I'm working as a legal counsel, which proves to be really helpful when it comes to challenging pushbacks and supporting the respect for refugee rights. As we already heard of Gianfranco, what is happening has been decisive, not only for the people on the move who have been affected by pushbacks at the Italian-Slovenian border, but it has an importance, and it will have in the future a big importance in what we can do, what we are able to do in Austria. When we founded Pushback Alarm Austria, there have already been pushbacks happening and pushbacks administrated along the Balkans for at least 5 years. There have been first attempts to document pushbacks from 2017. And we see that this practice has been spread from one country to the other, until it finally hit Austria too. So for us, the very valuable work our colleagues and friends in Italy, in Slovenia, in Croatia, in Serbia, and in Hungary has been crucial in developing our work and our attempts to challenge pushbacks in Austria. We initiated with an 24-hour help phone for people on the move who already entered Austrian territory. Some of them decided to call us when already facing police forces after they've crossed the border. Other calls at our 24-hour hotline were from relatives who were in touch with their brothers and sisters who were crossing one border after the other, and then finally lost touch with them when they already approached Austrian territory. So part of what we do consists in keeping an eye on what is happening at the border and trying to provide direct support to people who already arrived in Austria and want to apply for asylum and are actually fearing to be pushed back immediately. And this resulted into litigation very, very quickly. I will tell you about the two court procedures Pushback Alarm Austria facilitated. When I say facilitated, I'm talking about the direct relation Gianfranco was already talking about, the direct relation and the intense relation it needs to encourage someone who has lost every security in life, who is ripped apart from its root, from his or her family, from his home, like a leaf in the wind practically, and it needs a very strong relation to the person to encourage the person to challenge the very authority who just removed him from a territory, despite the fact that this person is carrying rights. So we engaged in a very intense relation with both complainants and supported them on all human levels during the procedures, and were then happy to report the positive outcome of both procedures we facilitated to arrive in court. Obviously, there are a number of challenges we are facing. One of them is that the policies which are being applied not only in Austria but all over Europe, I'd say, are trying to make people on the move invisible. So how do you get in touch with someone who is being made invisible, who is to hide? This has been a huge challenge for us to make sure that people who arrive on Austrian territory know that there are people supporting their right to access to asylum procedure, how to enable a contact to them. There are other challenges we will be talking about today, which are more closely linked to the necessities of court procedure. But I was extremely happy to hear about the idea of talking about strategies today, and I'm very glad I can be part of this discussion, because for me, and I guess for Pushback Alarm as a whole, litigation has always been an important part of our strategy to tackle pushbacks initiating at Austrian borders. When I talk about the first verdict, I'm talking about the case concerning 7 Moroccan nationals who were pushed back in September 28, only 15 kilometers from where I'm sitting now at the Styrian-Slovenian border. And this case had a number of direct effects. There were already in the court room, there were a number of people attending, but especially the whole mobilization around the court procedure and media reports afterwards created for the first time a broad public awareness about the fact that there are pushbacks happening at Austrian borders, and this specific awareness was especially strong in the region where the pushbacks were happening, where people were really shocked about the fact to hear that only an hour's drive from where they are living, people are being apprehended and stripped of their rights and pushed back to Slovenia, Croatia, and further to Bosnia within only 48 hours. Pushbacks thereby became an issue in the broader movement for refugee rights in Austria, which is a movement obviously tackling many different issues. But the pushback issue showed that there has been a new a new method being applied by authorities to remove people from the country, despite the fact that the Dublin procedure or the asylum procedure is as such is in many cases used to remove people from the territory that are, in our view, in need of international protection. As a result of the first verdict, there were first media reports in the region and all over Austria in governmental media or traditional media. As a result of the first verdict, we had an MEP, a member of the European Parliament, visit the very border crossing point people were being pushed back from. The first verdict was strengthening ties with our international networks, and it proves to be extremely valuable for us to exchange our experiences at a comparative law level to gain new insights and new ideas on how to move forward. We gained from the first verdict specific knowledge about the specific procedures being applied by the authorities, the legal basis of the police action, and what has been very important to us, first official numbers about actual pushbacks happening. Obviously, police during the court procedure named them as returns, but this was for us a first chance to get an idea of how many pushbacks are happening. So the court procedure itself was a very important tool for knowledge production about the specific issue.
I will come to an end of the first part soon.
When it comes to the second verdict that was issued in February 22, we saw that the court's message and the court's findings became even more clear and to the point. We have now a court ruling saying that there was an actual a breach of Article 3 of the European Human Rights Convention, and was specifically referring to documentations on chain pushbacks throughout the Balkans. So we see that there is a strong link between documentation attempts that have been brought forward for the past 5 years by a number of human rights organizations and activists. And we are very glad that at our anniversary, practically after 1 year of Pushback Alarm Austria, we were able to join one of the most effective networks, I would say, that is currently working on documenting and tackling pushbacks, which is Border Violence Monitoring Network. So to conclude, for me, the question if strategic litigation is an important tool to stop pushbacks, my answer is obviously yes, and I'm very much looking forward to enter into a discussion with my fellow speakers and you as a participants to put a light on the many fields strategic litigation can strengthen and can create positive synergies with. Thanks a lot.
Yeah, thank you, Petra. So now we come to our third speaker, Nikola Kovacevic. He's a human rights lawyer from Serbia and won the 2021 Nansen Refugee Award for Europe for his contribution to the development of the Serbian asylum system, as he represented. Sorry? All good? Okay. As he represented almost 30% of persons granted asylum in Serbia. And he's also documenting and challenging illegal border practices. He is involved in projects which are under the auspices of the European Council on Refugee and Exiles. He has almost 10 years of experience in litigating asylum cases at the national and international level, including in cases that imply a need for cross-border cooperation with regard to Hungary, Croatia, and Bulgaria. He has litigated cases of collective expulsions, the arbitrary deprivation of liberty at transit zones, the flawed application of the safe third country concepts, and others. Furthermore, he's a teaching assistant at the Union University School of Law, where he's teaching criminal law and finishing his PhD. So, Nikola, please, the floor is yours.
Thank you, Monika. It's a pleasure to be here and to speak about the topic for which I believe is very important, and at the same time, I believe the power of strategic litigation, this situation in which one case can impact the system and can, to a certain extent, undermine its bad essence. I really believe the strategic litigation, not only because I'm a lawyer, but because I really had the opportunity to be a part of the cases in which I saw how one case, which implies one or two persons, has forced the states to reorganize at least, or like to a certain extent try to design new ways to deny people access to territory and access to protection. So I'm not going to repeat what the previous speaker have already said, because I completely agree with them about basically all the things which they said and which can be considered to be challenges to do a proper case before the domestic authorities or before the European Court of Human Rights. The first challenging thing is these are the people on the move, and especially if you come from a country like mine, these people do not consider Serbia, for example, as a safe as a country where they want to stay and apply for asylum. But this is the place where the violation occurred. And this is the place where you have to litigate and collect the facts and bring those facts for you in front of the necessary body, and then stay in touch with these people. So since 2015, I've been extensively thinking about what would be the best way to organize individuals, civil society, different networks, what would be the best way to challenge Frontex, to challenge border guards, to challenge millions of euros which are being put into the technology, into barbed wire fences and everything. And I realized that, yes, of course, it's good when you're an individual, when you're working for a CSO, which understands that this is bad, that this is not working. But what I understand is that, you know, I know that even though in our regions there are a lot of individuals and NGOs and networks who are dealing with this, I know that these structures are not stable enough to provide constant response to something that is constantly happening. So it's compiled of enthusiasts, of wonderful people who are willing to work 24 hours a day. But one of the things which I realized is that it is very important to understand the local context. And I also believe that this is the role of each and every individual NGO, its own state. So the idea on how to increase the number of cases which can be strategically litigated and what would be the best strategy, definitely it's networking, but I believe that in each and every state, there should be at least one NGO or several persons who will constantly deal with this issue, who will constantly be present at specific borders. So my country is geographically located and it's surrounded by the external borders of the European Union. So I have Romania, Hungary, and Croatia to deal with if I want to work on pushbacks when it comes to pushbacks from EU to Serbia. And then there is Bulgaria and Macedonia. And each and every border is very specific. It's very particular. So each border has different trends. Each border has different communities. These communities have different rules. So these are the things, and every border police has its own approaches and its own strategies how to do this kind of things. So I believe that, you know, in order for strategic litigation to be used more, or to be used in the same way as for today, for example, we have reporting, we have advocacy, and all of this is important, but we have had reporting and advocacy for such a long time, but the situation is the same. I believe that we should design the new generation of lawyers and activists who will have a very specific knowledge on this particular issue. And this implies that you need to understand the local context in a specific border. This implies that you need to know the nature and all the layers of one pushback. What are the violations which happen in this particular time? This also means that you need to know the law. So you need to follow the jurisprudence of the European Court of Human Rights, which is sometimes very good. Sometimes you cry when you read the judgments such as ND and NT. So there are different, and then when you know all of this, the next step would be to have motivated people, motivated field workers who are not only field workers and activist enthusiasts, but the people who know how to apply the different interviewing techniques, which will deepen the relationship of trust with the person on the move. How to collect facts and which facts are important to you. Know which facts you need to collect when you know the jurisprudence of the European Court of Human Rights. So this is, and of course, if you know the trends at one specific border, these interviews, which usually happen in the bushes, on the side roads, in the different informal settlements, and especially when they happen right after the pushback or like day after, 2 days after, this is not a situation in which you can discuss and speak with this person for 3 hours, for 4 hours. So you need to do your homework before you approach a person, and then you will waste less of his or her time. But at the same time, this person will see that you're someone who knows what you're talking about. You're not just a researcher with a questionnaire who's trying to apply it for the first time. You're a person who completely knows all the trends. So and this is the local context. And the second thing, which I also believe is super important, is that you need to have the same group of people or the same individuals on the other side of the border. Why am I saying this? I'm saying this because I came up with this understanding, not because I read the manual or something, but because in 2015, when Hungary sealed with the barbed wire fence the border with Serbia, I was called by my friends and colleagues from Hungarian Helsinki Committee, and they told me there are first two persons who were allowed to enter Hungary under this new regime, which implies detention and then automatic expulsion to Serbia on the basis that it's safe. So we have two first people who arrived, and we need to find them because they're going to be kicked out somewhere in the middle of nowhere. They will not be surrendered by readmission to Serbian authorities. They will be kicked out at one of the barbed wire fences. So this is what it is. Okay, I have to be on the other side. Okay, I understand. We cannot anticipate when these people are going to come. So what I did, I jumped in my car, I drove to the northern border, and I found two men from Bangladesh who are called Ilyas and Ahmed. So Ilyas and Ahmed are the first grand chamber case. It was not a typical pushback case, but it was a case which is very closely related to the border policies. And on that night, I realized how important it is to act in solidarity with your fellow colleagues on the other side of the border, to be there, to receive them, to give them blankets, to give them food, to give them coffee, to become friends with them on Facebook, to beg your interpreter because you don't speak Urdu language, to establish a deeper connection because they're going to leave. One ended up in Tenerife, the other one is somewhere in Germany. And the case was, going from 2015 to 2019. So for 5 years, we waited for a judgment in which the European Court of Human Rights and the Grand Chamber said you cannot automatically apply the safe third country concept at the very border without certain procedural guarantees. But it took us 5 years and so many dramatic moments when the court asks, are you still in touch with your lawyer? This is just one of the cases which I believe outlines the importance of cross-border cooperation, but also the importance of people who are being a part of the cross-border cooperation to do their homework prior being dispatched to one of these areas. Another case which proves the theory of cross-border cooperation, at least from my side, is my case, which I litigated before the Serbian Constitutional Court. but also now which I litigate before the European Court of Human Rights. It was a case where a group of Afghan refugees, 17, I put some links in the chat, I don't know if you can see it, was pushed back to Bulgaria, and I could not go to Sofia. I called my friend Georgi from Bulgarian Helsinki Committee and told him what happened and asking, can you please, I know that they are arrested, but can you please find out where these 17 people, 3 families, several individuals are being sent? And he's the one who collected power of attorney for me. He's the one who collected the testimonies, and he's the one who helped me to establish the relationship of trust and to be in touch with 17 different people, even today when the case is pending before the European Court of Human Rights. So to conclude, I believe that, networks are super important. I believe that strategic litigation for me is something which is not exploited sufficiently. And I believe that if a better networking is established, in different areas, and if these networks are consisted of individuals and organizations who have the proper background to deal with the cross-border issues, with border human rights violations, I believe that the number of strategic litigation cases would not be 10, 15, or 20 that we have, I believe, like on domestic and international level in our entire region. But I believe if you have, for instance, 74,000 pushbacks happened from Hungary to Serbia last year. So this is the official data of Hungarian Immigration Service. So if we cannot get 15 to 20 strategic litigation cases only from that border, then we are not capable enough. I know when I say this is what I want and what I believe, but at the same time, if you ask me what am I doing right now, I have a very small funding and only one person who goes every second week to Serbo-Hungarian border. So dealing with cross-border issues, dealing with pushbacks, dealing with strategic litigation, it implies a lot of resources. It implies investing in generation of future activists and lawyers who will be capable to do this. And it implies that you need to have proper funding because, yes, we can operate on enthusiasm and I can jump in my car and go whenever I want, but I cannot do this forever. And if they have this organized deal behind the closed doors, which implies everything, millions, technology, thermovision cameras, drones, sensor movements, Frontex and everything, then at least what we can do is to the resources that we have to network them properly and to try to find funding, because without funding, you cannot motivate people to live for 2 or 3 weeks at one border crossing to understand the trends, which I did because I wanted to do it, but it is not sustainable. So these are so if you ask me do you think strategic litigation can help? I definitely believe that it can help. I know how many times only Hungarian policy shifted, even though it's still disastrous, but I know how the legal system was changing. And I know, for example, how in the case of Madina Hosseini versus Croatia, how for the first time you could see public officials admitting that something like this is happening, not denying. So the admission is always the first step. So, these are, the biggest challenge for me is funding. The second challenge is how to stay in touch with people on the move and build this and establish the relationship of trust. And the third thing is to build new generation of people who are willing to get involved into this, but in a proper way. So basically to have a very particular profile of a person who will deal with pushbacks. So hopefully I didn't take too much of your time, and I'm very much looking forward to any of the questions, discussions, and everything. So once again, thank you for having me.
Thank you, Nikola, and thank you to all 3 of you. I think we should take now some minutes to talk among us or among you especially. Still, I would like, you can ignore me, that's fine, but I would like a bit to play maybe the advocatus diaboli, maybe this is too strong a word, also as the only non-lawyer, okay, better non-legal, whatever person here. I agree with you that it is important to focus also on the strategic part of litigation. And now when I listen to you, and I'm also part of Pushback Alarm Austria, I know that, we need a lot of time and a lot of resources for these cases, mostly all of our time, I would say. And also, Nikola described it now very well, how this works. And I would just like to put in 2 sentences. One which came to my mind actually was Gianfranco, when we had this open border conference and we were sitting and talking, and he said, you know what, we have now to defend the Dublin system. And I was like, oh, wow. And obviously, when we're talking about illegal acts, we are also not accepting, but somehow we are working in this field where even the state or the European Union or whoever is acting against its own laws. And at the same time, I mean, if this is all we are doing, I'm not saying, I'm really just trying that what constitutionally, then we'll probably soon deal with this pact on asylum and migration, and we have like whatever border procedures and, you know, and procedures in Libya, whatever there is. And this also, the second sentence is one that I like to use when we are talking with newspapers or whatever, and I say, well, you know, we are doing a very non-radical thing. We are telling the state it should obey its own laws. You cannot be less radical than that, which is not true, I know. I mean, but so this is my point somehow, which I would like to throw into your discussion now, how to deal with the fact that in fact we want another system, also another legal system. I don't know. So please, maybe very short contributions, and then we open up for the other ones. Who wants to start? I have no preference here.
Okay.
Gianfranco, yes, please.
Okay. Yes. Monica, remember that when I in Vienna, I say with a paradox that I defend the Dublin rule, be like an important barrier against illegality. It's really because the fundamental question of pushbacks from Italy, but I know even from other countries, is that is a practice. An experiment. I think it's a great political experiment that to change the actual legality. Okay, maybe it's not good legality, but in the case a legality system with another system parallel, in a sort of a parallel system, but it's really not illegal, completely not illegal, but it appears like legally. The story of Italy was very interesting in which sense, because till the May of 2020, readmission more or less didn't happen on Italian border. Okay, it really happened, sometimes. But the number is very few. Number is very few, and in any case, situation was not so bad, because more or less all the asylum seekers can apply for asylum at the Italian border, and so okay, they entered, and then okay, we have a normal procedure, even Dublin procedure, maybe. What happened at May of 2 years ago? It happens that Italian government decide, and we know even the day, exact day, is 15th of May. It decided with a secret note to give order to a border police to violate. And they imagine that we have in the center of pandemic situation. Okay, you remember the general framework, and they think that okay, asylum seekers don't care to anybody, and so we have others more important things to follow, and so they think that never happened, and so they don't try to abscond this situation, but on the other side, they try to have a revindication, so an ideological revindication of that. If I show you this important document, I hope to don't I don't know if just a moment. I hope to not make a mistake. No, non ci siamo proprio. Non ci siamo. Vediamo se riusciamo. Excuse me. No. No, okay, no, not important. Okay. When Italian, I show later. No, the decision of Italian court in Rome, in which we have make this appeal to against the pushbacks of one Pakistan man who tried to make asylum in Italy, but the police avoid to make that. And so Italian government, on the first time on parliament, for Italian parliament, reply that, okay, it's legal to avoid to a man who come from Slovenia to present an application for about asylum on the Italian border. It's legal because this person comes from Slovenia. Slovenia is a sure country, and in any case, the readmission agreement may apply even in an old readmission agreement of 20 years ago from Italy to Slovenia. It's maybe applied only, not only, it's applied to asylum seekers like all the others migrants. This is not really completely false, but they try to continue even during the appeal to create a new law that doesn't exist. Really, I think for me it was is not a legal experience, it's not a social, but it was a dream experience. Till now, I don't understand how it was possible that for 1 year, and not for a year, but because they this situation stopped after 6 months, but produce 1,300 persons who are pushed back from Italy, mainly Afghans and Pakistan, and this person finished in a very bad situation. But Italian government tried to convince public opinion and even the judge, at least, that we have a new approach. We have a new, like if they try to say that the border is a special place. Is a special place in which have a special rule. We don't know our rule. In any case, they don't understand. But we have seen a very dangerous experiment. Very dangerous because all the rights of a person on the border was suspended in this period, and they know very well that this person, when they are pushbacks, disappeared in other country, and they have no documents, for example, and they have other problems for survival. And they try to make the game again, and they are not in the mind of them. They are not the possibility to make a legal action against Italy. They are, because they are only refugees. We have documents, we have a house, we have a lawyer, we have nothing. And so really, and particularly, they haven't any documents in which are the demonstration of the pushbacks. Till now, the main thesis of Italian government that in our case that we have win in the court of Rome, that is this person doesn't exist because it's because pushbacks may be informal. It's impossible informal, because it's a decision against a person. We have a decision, this person are forced to come back, and so we have a violation of freedom, a violation of, and it's impossible that all of that may be informal. but that really happened because police don't want to leave any documents with this person, and they think it is a correct thing that this person disappeared, and the great number of persons we try to contact really disappeared, and for us it was very difficult to start the legal action because they don't have passport, they don't have a house, it's impossible to reach them, they move every day in different places, etc., etc. At the end, we have found a very determined boy who tried to receive his national passport, decided to stay in Bosnia, stop for several months, and we assist him, and step by step we have demonstrated that his illegal pushback was illegal, really, no? But the principal obstacle we have found is the question to have a good assistant to a person who have not right at all, because they are illegal in Bosnia, they are illegal in any place, and so it's important that this story, because on the legal question is very easy. Pushbacks of asylum seeker is illegal. It's not difficult to understand, because against the Dublin rule, against the Italian law, against the European directive, is against the Geneva Convention, etc. But the main difficult is to demonstrate that all the facts are really happened. And the person have the possibility to go to the justice, and so I think is a model, a bad model actually for Europe. I underline only last thing, in my opinion, is more important. If you I don't know if how many persons have noted that European Commission in December of the last year have presented a proposal of a new rule to change some articles of European law again about Schengen, Schengen circulation, the rule of Schengen. And the proposal, what Commission say in this proposal? The Commission try to write an incredible proposal, really incredible. It's really even is a proposal to change the article of Schengen Code, Schengen Charter, in which and so to make readmission as a normal system against among European countries we have a common internal border, and because and if this new proposal of the Commission can started or can approved, we have had a new very bad situation, because we must to fight against a new law, which is not respect international law and other European law. And so I tell this story because I'm sure that all these questions of readmission inside Europe are a signal of this situation of that deterioration. I don't know it's in English generally law system, of a right system for fundamental rights, and all European citizens are in danger about that, because this European state have not decided to violate the law in a very strong way, really very strong way.
Okay, thank you. Petra, Nikola, short statements, please. We are we have nearly 1 hour now, and we should really get to the other participants. But please, Petra.
Yeah, it's really love to hear the statements of participants, because I already was reading in the chat that there are people who joined us today that had the experience themselves to be afraid of a pushback and to fear for their life during their trip across the Balkans. I think intervening in pushback practices legally and on other levels is extremely powerful, because the state and state authorities don't respect their own rules. Even in other fields of the asylum procedure, we see highly problematic decisions being taken by authorities and courts on a daily basis. But why is it so powerful, and why do we see immediate effects after even just 1 or 2 verdicts, which is extremely rare in our political practices? I think because authorities realize that they exaggerate when they break their own rules, because we never saw so direct and strong responses, even from official media, from the general public, and from other actors when it came to problematic legal decisions infringing on rights, on asylum rights, or on rights of people on the move on other levels. But when it comes to the state breaching its own laws, then it becomes very problematic if these practices are being exposed. So this is not only true for pushback practices, this is true for all the other fields where rights of extremely vulnerable people are being stripped away. But I think it is important to realize that intervening in this very specific field has an extreme power that affects not only the fact of pushbacks, but it exposes other state practices, and it exposes them on a much bigger level than we can usually achieve by our activities and by our attempts to create awareness, to involve more people, to make sure media reports on what is going on. So I think we should see mobilization around pushbacks with litigation as its most powerful tool and core as one of the means to challenge general strategies that are currently being employed to reduce and infringe on the rights of people on the move. And that is why I think it is so extremely powerful to put our finger into this open wound of pushbacks.
Thank you, Petra. Nikola.
Thank you. Maybe to just a couple of more remarks, but I believe that the vast majority of things which are relevant have already been said, and that it would be good to open the floor to the attendees. So, as I mentioned, when we speak about the current state of affairs, which implies, and I agree with Petra, complete denial of the situation in which state violates its own rules at its own borders, and in that the same way creates another illegal situation, which implies smuggling, human trafficking, and many other stuff. Maybe the last thing which I would like to outline is that the situation in Ukraine has showed us that this is not being done on the level which implies that, you know, this has not been done unintentionally, that this is a very well-designed and established practice, which is a deal of the European Union behind the closed doors. So a couple of days ago, I was discussing with my colleagues in Poland how the situation shifted from one to another. We had a summer situation in 2020, when we had thousands of people from Middle East, from Africa, coming from Belarus to Poland, Latvia, Lithuania. And there was a state of emergency, barbed wire fence, soldiers, police officers on one side, and then several months after, or a year after, not years, 7 or 8 months after, very obvious act of aggression of Russia towards Ukraine, which triggered mass movement from Ukraine to European Union. And then from pictures where you can see Polish border guards using a pepper spray in arms with police buttons, German shepherds, to the situation which you can see Polish border guards carrying children from one part to another from Ukraine. Being involved into this issue in general, but especially from the strategic litigation point of view, is also important for preservation of European values, of the values of international human rights law, which have been established and designed in the continents such as ours, which was triggered by the mass movement of refugees 75 years ago. So I also believe that, I cannot add anything else on the things, but maybe to outline why I believe the importance of the rule of law at the borders and respect for human rights and solidarity at the borders is important, because if we lose the battle at the borders, which implies that some other people from somewhere else are completely denied their human dignity, I believe that this will strongly reflect on other segments of our life in Europe in general. And this is why I also believe that what we do, it's important, and we can discuss and have our collective psychotherapies on how can we do this better. But at the same time, I also believe that we should always tend to explain, why are we at these borders? Why are we documenting these violations? Why are we speaking to these people in informal settlements? Why are we willing to sit down with them in some remote area, in some bushes, and document this? Because by protecting their rights, by protecting their fundamental right to access safety and protection, we are potentially protecting rights of some other people who might come as refugees in the future. And as you can see from your neighborhood, it is not impossible that mass displacement happens in the continent of Europe as well. So this is why it is important not to make differentiation. So I would just like to add that it is very important. Yes, we do what we do. I don't have anything else to add on strategic litigation and pushbacks, but also to communicate with the outside world. Why is this important? Why is the case of small Madina Hosseini from Croatia, from Afghanistan, who died in Croatia, who was killed by a train? So this young girl, she gave her life to remind us Europeans before the European Court of Human Rights why you cannot do this kind of stuff, and why do we need these kind of cases to happen in order to understand this. So the last thing which I would like to add is communication, trying to explain what are we doing, that we are not some people who are trying to find a way around the border policies, but the people who are promoting the balance between the security on one side and the human rights on the other side. So these two things are not contradicting each other. They have to be interpreted in harmony. So yeah, that would be the last thing which I would like to add when it comes to, the message that we also want to send when we resort to different methods to tackle illegal border practices, including by means of strategic litigation. Thank you.
Thank you, Nikola. Thank you all of